Please be seated. We'll hear argument in case number 240171, Maya Walnut versus Lee.
Please the court. Mr. McCarty will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
Good morning. I appreciate the opportunity to present Maya's case to the court. And this case gives this court an opportunity to decide whether a party who holds a monopoly on the truth can use that monopoly to commit a deliberate fraud and then be shielded by the red flag doctrine. Here, my client Maya built a successful, robust grocery business in a particular neighborhood in Dallas over the course of almost 10 years, only to see it leased away by its landlord, Walnut Creek, to Maya's biggest competitor, El Rancho. And were that the end of the story, none of us would be here today, but it wasn't the end of the story. Instead, after Walnut Creek leased the premises to El Rancho, Walnut Creek commenced a 6-month-long campaign of fraud against my client Maya to induce Maya to focus on its current premises, to release those premises, as opposed to pursuing other alternate premises in the neighborhood where it could continue competing in the grocery business there. There were, as Mr. Lee, who was Walnut Creek's representative, said, they continued negotiations with Maya from August to December, when the lease had been signed already in August. And there were specific representations. Not only were there entreaties to continue negotiations, continue setting up meetings, etc.
Was there anything in the record about what the incentive was for them to do that? Not the incentive of the new lessee, but of the owner.
Absolutely, Your Honor. And it was that there were two specific provisions that the jury saw in the lease. One was a non-disclosure agreement in the lease. And that non-disclosure agreement, as Mr. Lee testified, prevented him from telling Maya about the El Rancho lease.
Was there some testimony that it was El Rancho that insisted on the NDA?
Your Honor, there was testimony to that effect, yes. Now, it's also important, however, to realize El Rancho protected Walnut Creek because of another provision in the lease, which I would say is quite unusual. There was an indemnity agreement in the lease whereby El Rancho said, Maya, we will reimburse you for legal expenses. I'm sorry, Walnut Creek, we will reimburse you for legal expenses if Maya sues over the termination of the lease. So there's no question that the parties here knew what was coming from whatever arrangement there was, but the important thing is all of this course of conduct ultimately deprived Maya from being a competitor to Walnut Creek's new valuable client, El Rancho.
Well, Counselor, going back to Justice Lerman's question, it's helpful to have your mastery of the record there, but to prove fraud, I think you have to show that that Walnut Creek intended to induce Maya to act upon the misrepresentation. So to the question of incentive or motive, I mean, maybe it's like the Chris Rock bit about like, she's trying to destroy me, but what incentive did Walnut Creek have to help El Rancho destroy Maya as a competitor?
Well, it's very clear that Walnut Creek viewed El Rancho as a very valuable tenant that was paying significantly more in rent than Maya.
So to that end, if Maya had matched market rates in connection with rent, would they have been allowed to remain in the space?
There was never, and this is quite, well, two things. One, it was never proven to the jury that the market rate was $11.25 a square foot. right? Which
What
was,
did El Rancho pay for it?
El Rancho had offered $725 a foot. And so there was a significant difference
I
between.
thought it was Maya.
Maya
that-
had?
I'm sorry, Maya
Yeah.
had offered $725. I apologize for that. Maya had offered $725 a foot. And
So is it your position that negotiations would have culminated in a new lease, and the new lease would have been at Maya's offer of $725 a foot?
no, that's
Okay.
not and it's very important, and I'm glad
Because
you asked
this
that
is
question.
kind of the opposite of most of these cases. Most of these cases, it would be, you promised to release, right? And if you, and then you meanwhile found another tenant at a better deal, and so you broke the promise to release. But here, I think it's undisputed that there was never an agreement to release.
Absolutely, there was never an agreement to release, and that is not the fraud that we have contended ever in this case, including at the Court of Appeals or, of course,
But is
before
that
the
the
jury.
damages? Because it's lost profits, right?
Well, the damages are lost profits via the loss of its business, yes.
But that's a challenge the Court of Appeals didn't reach
That's right.
on the damages.
Yes, there are several pre-terminated issues at the Court of Appeals. So it's not a question that's before this court today.
Or causation, I guess.
Yes, well,
Causation and damages were briefed in the Court of Appeals but not reached.
those issues, yes, and they're not in front of this court today. So the question in front of the court today really is, can El Rancho claim that although it clearly induced Maya to engage in these negotiations until just after the only alternate premise in the neighborhood was leased to someone else, can Walnut Creek claim that all of that doesn't matter because Maya should have made a better business decision even under the cloud of fraud? And that's really where the Dallas Court of Appeals went. The Dallas Court of Appeals agreed with Walnut Creek's argument that it could not, given all of these things, it could not have been Maya's best business decision to pursue the better premises where they currently were instead of going down the street to an alternate location.
So I understand your argument about what the Court of Appeals did wrong, but we have to analyze that issue for ourselves. And I understand your argument that you just made on why there was a misrepresentation here. But the issue the Court of Appeals decided was the reliance justifiable? And they said no because of the red flags and you didn't investigate and that sort of thing. And so can you help us understand how the red flag doctrine should apply in a case like this? Because the only cases where we've applied it, there were lots of red flags.
Yep.
And, assume with me, and I know you don't agree with this, that maybe there are some red flags here, but one or two, and not, 5 or 6 like in the other cases we've had. Where can we look for guidance on how many red flags is enough?
I don't think it's a matter of how many. I think it's a matter of, first it's a matter for the jury. In other words, can the jury say there was actual reliance based on
Justifiable.
Yeah, well, actual.
I mean, actual and justifiable, right? Both of those were submitted in the jury charge.
Well, the jury charge did follow the pattern jury charge, which acts for reliance. And so, of course, had the jury heard, El Rancho, for instance, told Maya, hey, we've leased your premises, okay? But yet, Walnut Creek continued on this scheme of fraud. Well, of course, the jury would have never come back and decided, you relied. Maya relied on that. They would have, like any of us would have, decided against that. But to your question, how many...
What did Maya rely on? They relied on continued negotiations?
Mm-hmm. Yes, they relied on
And
continued negotiations.
even though,
I thought your position was that they relied on a representation that the premises were presently available to lease.
Well, through continued negotiations. I mean, that is
Well,
a
that's the way it was
fundamental-
conveyed, but because there were statements like, because there is ample time remaining, we'll continue discussing the final terms in the near future in August. Or in December, when they had a draft, we'll come back with an agreement to $725 or $750 a square foot within a week.
Right.
So that, and your position is that those are representations that the premises were available at the time those were made to be leased.
Correct. And I'm sorry if I'm splitting hairs, because the continued negotiations were all premised and founded upon the idea that the premises were still available for lease when they were not, right? They're two sides of the same coin, I think.
So does that color the way that we think about what the relevant red flags are in this case? If we were to agree with you, just assuming hypothetically that the misrepresentation is of a present ability, that the lease is presently available to be renewed, which red flags are not relevant to that,
Well,
that misrepresentation?
I think you are absolutely correct that is the question. What red flags were to that point? Because many of them are not. For instance, long and difficult negotiations. Well, they did have time to negotiate the lease on these premises. My client, Maya, wanted to start construction, but they had time. And so, like all of us here, I suspect, we've been in a mediation. The mediation's supposed to go from 9 to 6. But until 3:30 or 4 o'clock in the afternoon, nobody gets serious. And so, long and difficult negotiations alone are not enough. The fact that the parties negotiated arm's length, well, that doesn't tell us that the premises were released. There is one, and I want to be fair, there is one red flag that may have gone to whether the premises were leased to another, right? And that was when my client read some website, et cetera, of his competitor El Rancho, and they said, we have a big surprise to announce later, right? And he said, I wonder what that is. So in response to that.
Did he use any diligence at that point in time?
Yes,
Is that-
as he testified and the jury heard, they continued to reach out more frequently to the only party that they could go to, right, which was their landlord. And their landlord never said, hey, we're concluded with our negotiations. We're stopped. Or the premises are no longer available to you, Maya, which is all they
Does
had
the
to say.
diligence that's required at that point necessarily have to do with pressing further on the specific question of, is this particular premises leased and to who, to my competitor, finding out that, right? We're talking about investigation. I'm just wondering what really is required. Is it further investigation to that specific point, or is it just more self-protection?
Well,
in the form of, for example, looking for a different option?
Well, my client did look for a different option and had identified one, but it believed that its better option as a business was to remain in its current premises.
Does the record show for that, I think it was the one that ended up getting snatched up in January, does the record show what the price per square foot for that one was?
It did not.
Okay.
That seems pretty relevant to your damages.
Well, not if the damages as they were presented was the value of Maya's business, which in that neighborhood. So there was a lot of discussion. Both
Well,
by
and I know the damages aren't before us, but that seems to get into questions of causation and damages as far as the self-protection issues. But I think one possible way to think about it is that in Orca we said, if we assume that maybe there could have been more that, I know you don't agree with this, but if we were to conclude that more investigation could have been done, or more ordinary care could have been exercised, I think what we said in Orca Assets is that you would be charged with knowledge of all facts that would have been discovered by a reasonably prudent person similarly situated. Mm-hmm. So what does the record show us about that? What would, if you had exercised all the ordinary care that they wanted you to exercise, that your opposing party says you should have exercised, what does the record show us you would have discovered or not?
Well, we would not have discovered anything because in Orca, critically in Orca. All they had to do was go to the public records to find out whether those leases were available. Here, there are no public records of private leases for premises. There were only two parties who knew, and those parties committed themselves by contract not to disclose.
Did you ask, are you negotiating with other people?
They did not ask that. My client.
Would that be the equivalent of going to the public records at least?
Absolutely not.
Why
The
not?
public records, first of all, give you a direct answer, yes or no. They are public records, period, which Orca could have done, and they could have found the truth. Going to.
You don't think as a matter of diligence, if you're really wanting to stay in your location, you have a contract that doesn't give you any right to notice, your landlord is saying, look, I'm just tired of talking, I don't even want to talk to you for the rest of this year, to not just say, wait, are you talking to anybody else, would be something that a diligent party would have done?
Well, importantly, Your Honor, they didn't say, we're not talking to you anymore. They said instead, we'll negotiate next year, but
Yeah,
we're.
we'll get back to you next year, we're in August. I mean, if you're dating a girl and she says in August, you know, let's not see each other, let's talk again next year. I mean,
But.
Red flag, maybe?
But in August, but.
So you're telling me there's a chance, right?
But in August, because there's a next part
Didn't they
of
tell
that.
them there was a chance, though? They said,
Yes.
because there is ample time remaining, we'll continue discussing the final terms in the near
Terms, right now.
future.
We'll
But
discuss
it's a red
marriage.
flag. That's the question. Why isn't it, you're just saying none of these are even red flags, and maybe they're not, the biggest, flag like you'd have at an auto dealership or something, but they seem kind of red, kind of
Well,
flaggy.
Your Honor, I agree with the premise that if all they had said was, we'll negotiate next year and gone silent, that would have been a bad idea. But instead, what they said was, we'll discuss final terms in the near future. In other words, we'll discuss maybe whether we're getting married, and then we'll decide whether we're going to get engaged next year.
So they let you know 8 months ahead
Mm-hmm.
of the termination of the lease. Under your theory, when should they have let you know?
They
In order
should,
for you to arrange for alternative space?
well, I would put your question slightly differently. When should they have not lied to Maya? Because that's the question. Once they made the misrepresentation, then a whole another set of circumstances comes into play. Had they said at the 1st of August, we'll negotiate next year, and then at the end of August, they had said, well, look, I'm going to tell you what's actually going on. We've leased the premises to somebody else.
So August
would-
instead of when?
Well, January,
January.
but it's not,
So it's that time period.
that would have mitigated the damages. That would not have changed the misrepresentation. That would not have changed the fraud.
But it was a misrepresentation as to whether they would lease the premises to your client.
It was a misrepresentation as to whether the premises were available to my client. My client made its decisions
But there
under a
was
cloud of
no
fraud.
renewal provision in your lease.
No, they were riding on a clean slate.
And you did not reach an agreement about. So that's the part I'm having trouble with.
Your Honor, it's happy to address that, and that is simply that there was, and we have never contested the idea, that there was no right for us to release those premises, okay? We did not have that right. What we did have a right to, why we're before this court, is not to be defrauded.
To accurate information about the existing.
Well, not to be, look, as we said in our briefing, okay, somebody comes and you want to go buy a vehicle, okay, from somebody, and the vehicle's been in 3 major accidents. The guy you're buying the vehicle from doesn't have to say, hey, want to let you know this has been in 3 accidents, okay? But what he can't do is he can't say this is an accident-free vehicle.
So what about somebody selling a home
Mm-hmm.
that has 2 interested buyers and enters an earnest money contract with one, but continues negotiation with the other?
That would be fine, but there wasn't an earnest money contract here. There was a final contract to lease the premises. Walnut Creek had absolutely no right to leased those premises to Maya after the lease had already been signed with El Rancho. Walnut Creek's rights were extinguished to lease that property.
Any further questions? Thank you, counsel.
Thank you.
We'll hear from the respondent.
May it please the court, Ms. Johnson will present argument for the respondents.
Mr. Chief Justice, and may it please the court. The backdrop of this case, the court is well acquainted with. Two sophisticated commercial parties engaged in 3 years of lengthy negotiations, at which time they never reached agreement on material terms. The very sophisticated commercial tenant never secured any protections, any contractual rights, options, exclusive negotiating, or notice of non-renewal. Petitioners
But
using...
your client, the jury believed, misrepresented an existing fact as to the availability of the space. And their theory is that that hampered or dissuaded them from seeking alternative lease space. What is wrong with their theory of reliance in this case?
So a couple of responses, Your Honor. First of all, that is a new theory in this court. That's not the theory that they
Well,
tried.
it doesn't matter. If the
Right.
question is a no evidence question, then all
Absolutely.
we have to look at is there more than a scintilla of evidence of any misrepresentation?
And what they're asking this court to adopt is an implied fraud by continued negotiations. Absolutely no evidence of affirmative misrepresentations.
Because
They
there is
never-
ample time remaining, we'll continue discussing the final terms in the near future on August 1st, when the premises had already been leased.
And what they're asking the court to do is imply from that it was no longer possible for Maya to stay in the space, and that is factually wrong, Your Honor.
But there is not ample time remaining to negotiate a new lease at that point.
Yes, there.
How? What
There's
is-
15 months until the lease expired. What changed, and that is critical, 15 months, which is an eternity in the commercial space. They were offered a deal. It is not that a deal
They were
was-
offered a deal by El Rancho, not by
Yes.
Walnut Creek.
Yes, but
So
Walnut
what
Creek
authority
approved it.
did
The
Walnut-
landlord had to
Excuse me,
approve.
what
Sorry.
authority did Walnut Creek have on August 1st to discuss final terms with them on a space that had already been leased?
Because what happened was Maya went from being Plan A to Plan B. There are constantly parallel negotiations and commercial negotiations. And what happened was Brian said, it's still possible to do a deal with you. Everybody agrees,
Can
that's
you
undisputed,
show me how
Your Honor.
that's possible in
Yes.
the lease that
Yes.
Walnut Creek entered into with El Rancho?
El Rancho could walk away. El Rancho, the evidence in the record, 6 RR 228 to 29. They hinted that they might just move down the street to the Albertsons just a mile away. They had just been acquired. 45% of them had just been acquired by Albertsons. El Rancho could go bankrupt. Anything could happen. That lease could end. Brian was doing what commercial landlords do all the time, which is working on Plan B. Maya could walk away. Even Mr. Lee thought it was still possible that they might find better terms with El Rancho.
Well, go ahead.
Maybe you can work on Plan B, but don't you have a responsibility to let them know that they're Plan B at this point in time?
That, I think, Your Honor, that is really the key question. That's the exact question this case presents, and I answer that question no. And if this court decides that there is now an implied, first of all, you've got to decide there's implied representations, because there are no direct representations
There
here.
is ample time remaining.
There was ample time remaining, Your Honor. There was 15 months
Okay,
remaining.
I think the jury saw it differently.
There is ample time for El Rancho to possibly declare bankruptcy.
Yes, Your Honor. There are a million things that could have happened. Maya could have walked away. El Rancho offered. It's not that a deal was no longer possible. It's that the deal they wanted was no longer possible. They got offered a deal. This is undisputed in the record. Mr. Lee and Maya, both of their witnesses testified that they knew it was still possible to do a deal. When they learned about the El Rancho lease, first question, can we still do a deal? They knew it was still possible. Mr. Shalabi,
Does the record show why they turned down the deal at the end of the?
they didn't like the terms of it, Your Honor. The
Well,
same
I thought it
thing-
was at like $11 and something a square foot and a non-compete.
Right, it was a
Right.
deal they didn't like. Yeah, but that's the point, Your Honor. It's not
When
that
the
a deal was no
representation in
longer
December,
possible.
based on a agreement that was just waiting for a term on dollars, the representation was, we'll come up with an agreement to $725 or $750 a square foot within a week.
Your Honor, that is, I've just got to say this, that is an absolute misrepresentation of the record. I actually gave as an oral argument exhibit the exact testimony of Mr. Shalabi on this point. He did not say, there is absolutely no evidence that Mr. Lee made an affirmative representation that he would agree to $725 or $750. And if you read what this all comes from 5 RR 77 and 78. What he says there is this, and I'm going to quote, this is just, I'm sorry, but it's just a misrepresentation of what he says. He says, he gave us indication that he will go and talk to the owners, those are his parents, and come up with an agreement to agree to $750 and or $725. And then he goes on to say that he came back with a response. He did what he said he was going to do. That is not what the way they characterize in the Sharif as an unambiguous statement that he would agree to this. No such evidence in this record.
They're not suing on the fact that he didn't agree. They're suing on the representation that it was still possible to agree.
It was still possible to agree, Your Honor. They agreed to that. Let me give you the record sites. Their testimony where Mr. Shalabi is asked, was it still possible for you to do a deal with El Rancho after
El Rancho or Maya?
I'm sorry, with Maya, after the El Rancho lease? Yes.
With
5 RR.
I'm sorry, could you read exactly what the question said? Because I'm confused about the parties now.
I'm sorry. Was it still possible for for Maya and Walnut Creek to do a deal after the El Rancho lease? Yes. 5 RR 85 to 86.
But you said only if El Rancho agreed, right? Because they're the ones
Which
that
they
hold the
did,
lease.
Which they did. The evidence is undisputed on that too. El Rancho said, look, we may move down the street. If you get Maya to match terms, we'll move down the street. We'll assign our lease to them. They offered to assign their lease to them. They turned it down. Again, it wasn't that a deal was not possible. It's that the deal they wanted was not possible.
So if we disagree with you on that, let's talk about red flags.
Yes.
I'll ask you the same question I asked your friend on the other side. And you may not agree with this, but if we conclude that there are some red flags here, but not the overwhelming kinds of red flags that we've had in other cases, the justifiable reliance is a matter of law determination. So there needs to be really clear guidelines. I mean, it's not that the jury gets to decide whether the reliance was reasonable and justifiable. These red flag cases are cases where we're saying the jury can't even consider this because it's so clear that you couldn't have relied. So how many red flags is enough to put it in that category?
I think, Your Honor, the first case I would point the court to is Barrow-Shaver, because what we start here with is inherently unreliable statements, and Barrow-Shaver addressed that no reasonable commercial party relies on, let's talk next year, to Justice Young's question. I don't think anybody dating relies on, let's talk next year, or I'll get back to you later.
But might they rely on there's ample time remaining?
Your Honor, there was ample time remaining. It was 15 months.
I know, but assuming that, okay,
Well,
go ahead.
In Justice
It's not-
Young's amorous hypothetical, hey, maybe next year we'll get together, and it's like, because maybe my husband will die? I just don't understand.
Well, in a commercial lease negotiation, a lot of things can happen in 15 months. I mean, I want to throw out, too, the concept of an efficient breach. That, yes, Walnut Creek could have been negotiating with all kinds of parties, signed a lease with them, gotten a better deal with someone else, and decided to engage in an efficient breach, to breach their lease.
But I think what they're saying is that there was more than a scintilla of evidence that that's not what was represented.
Your Honor, all that was represented was, let's talk next year, I'll get back to you with final numbers. There was no affirmative representation. And to Justice Young's point, why didn't they ask the question? If they had asked the question, and I will concede this would be an entirely different case.
Why?
had
Because
said-
the NDA prevented them from answering.
Okay, the NDA, let's talk about the NDA.
Actually, I had a question about red flags that I don't think you
Oh,
finished
okay,
answering.
sorry.
But
Red flags, inherently unreliable statements. Admitted to this, in Barrow Shaver said these were inherently unverifiable statements of a vague intent for someone else to do something sometime in the future under some circumstances not yet known. Inherently unreliable statements. Admitted doubts, concerns, skepticism. He pointed out one. They knew that this was happening. They got a notice that El Rancho had a big surprise, and Mr. Shalabi, their owner, testified under oath that he suspected right then and there that they'd lost the Walnut Creek store. Admitted doubts and concerns. Maya.
So is your understanding or your suggestion of what the doctrine should be that only if you lie twice? Basically, they say, and the jury seems to agree, that your client lied to them once, and they should have said, hey, is it available? And then if Walnut Creek had said, sure, it's available, and that also wasn't true, that's what you have to do? What's the
Your
point
Honor,
of a red flag doctrine that
if
makes
that
you
were-
get lied to twice?
I don't think there was a first lie, first of all, Your Honor. There was never any
I understand that, but the
statement
jury
of-
disagreed
okay.
with you, so.
Okay, but to your hypothetical, that'd be an entirely different case, Your Honor. Yes. If
But
the
didn't they
question had
ask
been
again in
asked-
December?
I'm sorry?
Didn't they ask again? And, I mean, wasn't there another discussion that they say was an additional misrepresentation
Yeah,
of
but they
present
never asked-
availability in December?
They
And
never-
so, well, if it's repeated, then, to Justice Sullivan's point, didn't they get lied to twice?
They never asked, are you talking to someone else? Never asked it.
Well, why
In
would
all
you
of their
ask if,
cases.
why couldn't the jury have thought, why would you need to ask if they're repeating the same information to you about it's still available?
The question
never-
wouldn't be, are you talking to somebody else, would it? The question would be, did you go to our competitor and sign for 50% more per square foot than what we're talking about?
Either one of those questions would have been some level of diligence. I mean, the level of diligence has to be more than nothing. Neither of those questions were asked.
I'm not sure
Your Honor.
that's right, because Orca Assets said if there wasn't diligence, then what you do is not, you don't lose, you're just charged with knowledge of all facts that would have been discovered by a reasonably prudent person similarly situated. So what does the record show us as a matter of law they would have discovered if they had acted reasonably prudently?
Right, and if they had asked the question, are you talking to anybody else? Have you entered into an NDA? Anything.
How would they
And
even know to ask if you've entered into an NDA?
Well, okay, I mean, if they'd asked anything, Your Honor.
And that they could have asked, are you talking to anybody else? And the answer, I mean, under their lease, they should have expected that they were talking to other people. But the
Right.
misrepresentation that they're claiming is not that they were misrepresenting that they weren't talking to anybody else. It's that they had entered a deal with somebody.
Your Honor, to be clear, I just want to be clear, this whole fraud claim is it's representations, not omissions. They've abandoned that. And it is representations by implication of continued negotiations. If this court adopts that as a fraud theory, I think that's a massive change in Texas fraud law. Because
So
I don't.
it seems like it's a similar theory to fraudulent inducement of a contract, and there you evidence to the other side that you're going to perform on the contract, and you enter into an existing contract knowing all along you have a present intent not to perform. And there's reliance questions that come up in those cases too, and I'm just trying to figure out what the reliance analysis is when the present intent not to perform doesn't tie to an existing contract.
I think that's a great question.
How do we figure out whether what the legal test for justifiable reliance is?
Well, I think Barrow Shaver actually answers that question, because it also involves, in that case it was, don't worry, we're not going to assign, we'll agree to an assignment. And what the court said in that case is that the substance of the representation was inherently unverifiable, because it was about a person saying, oh yeah, I promise I'll do this in the future.
Yeah, but in that case, there was a provision was there a no assignment provision in the existing agreement?
Well, and I would say, Your Honor, the contract in this case is relevant too, because this is a very sophisticated commercial party who knew what kinds of protections to get, and in the lease they were negotiating with us included these protections. But they didn't obtain exclusive negotiating rights. They didn't obtain notice of non-renewal, absolutely no notice provision. We gave them 8 months' notice. I mean, one way to even look at this case is their real complaint is that they didn't get 15 months' notice of non-renewal. They only got 8 months of notice of non-renewal.
And that seems like a great argument for you on causation and damages.
Yes, Your Honor.
And so, but that's not before us. So I'm trying to focus on what's before us. How do we account for Italian Cowboy's observation that a commercial tenant is entitled to rely on a landlord to not actively conceal material information?
Well, this is not a concealment case. They've let that go. They haven't actively concealed.
Well, I mean, I think they would say that you're actively concealing it by making a representation that it's still available.
But that
when in
assumes
fact, which conceals the fact that it's not.
But that assumes a duty of disclosure, which I think they can see.
Well, that's
now
what we
don't
said there
have.
is in Italian Cowboy.
A duty of disclosure, but here, I don't think there's any dispute that there was no fiduciary relationship, no confidential relationship, no partial disclosure, no common law duty of disclosure here. Commercial landlords.
So why is it different from Italian Cowboy?
Well, I think, first of all, Italian Cowboy, and I'm sorry, that case isn't one that we've briefed, but it's in a fraudulent inducement case. It's not a red flags case. So this is about whether red flags, and by the way, let me just be clear about this. They concede that there's red flags. They concede, if you go through their briefs, they concede red flags. They concede red flags gave right to a duty of inquiry. And they concede that in the face of those red flags, that they engaged in no diligence at all.
Well, I'm not sure they concede that. I thought they said, well, in the face of that, we did what we could, which was to try harder to get an agreement with the landlord, and we also looked at this other space.
Which is exactly what Barrow Shaver says you should not do. In the face of red flags, you should not barrel forward with negotiations. You should stop and at least ask for the minimal basic inquiry of, are you talking to someone else? And
Well, the answer to that would have been yes, but that's not what they're suing about. What they've said is there's at least a scintilla of evidence, not just that they were talking to somebody else, but that they'd entered a contract with somebody else.
Right, they didn't ask that question either.
And you were going to tell me earlier, I think, and then we got sidetracked on something else about why the NDA would have allowed them to say yes to that.
Yes, a couple points on the MDA. We don't know what it said. It's not in the record. We have very sparse testimony about it. What we know is that the NDA did not prevent discovery of the fact that he was talking to anybody else or the existence of the lease. El Rancho disclosed the existence of the lease. Mr. Lee disclosed the NDA itself. He disclosed that ultimately that he believed it prohibited him from talking about the terms of the contract, but not the existence of the lease. So what we know for sure is that it didn't prevent Maya from discovering any material information. The other red herring is this indemnity provision, which again, these are things that came up. None of these had anything to do with the trial or of this matter. But indemnity provisions, Mr. Hurley and Mr. Shalabi both testified, 5 RR 41 and 182 to 83, that these are very common in commercial leases. They included it in the lease that they had with us. It was there because El Rancho was worried about Maya overstaying its lease, which in fact they tried to do, and that they were going to be forced into litigation, and they wanted to address that possibility up front. Nothing about these two things provides, to Justice Lehrman's very first question, what is the possible incentive that this landlord had? He had the
Well, I'd like to ask you a question about that with the time that you have remaining. I don't recall having seen this in your merits brief, but your friend in opposition accuses Walnut Creek of having conspired with El Rancho to eliminate Maya as a competitor. And in topside argument, maybe we'll hear more about it, but I think it was at least implied by your friend in opposition that the 50% delta between $11.25 per square foot versus $7.50 was basically a premium that El Rancho was willing to pay as kind of an anti-competitive bounty to knock out a competitor. And so I want to give you a chance at the podium since I didn't see it in your brief. What is your response to this?
There's absolutely no evidence of it. It's entirely concocted in the briefs in this court. There's absolutely no evidence of that. Nobody at trial even suggested this conspiracy theory. The only evidence at trial regarding Mr. Lee's incentives were that he wanted to get the best price for his family, for his family's
again,
business.
of course he wanted to, but was there not any discussion at the trial of why El Rancho was ready to pay 50% more than what Maya was?
None, Your Honor. Those were the market rates. The truth is, this was a very old lease from the 1960s. It was an incredible deal for them. And when they wanted to renew, they didn't want to pay much more. And so the negotiations went backwards. And that was when our client said, okay, look, we're stuck at $7. They've gone from $7.25 backwards to $7. We're going to go out and look for other buyers. And they found one who was willing to pay $11.25. And to Justice Bland's point, I just want to make this clear. If Maya had agreed to the terms of the El Rancho lease, they would be in that space today. This whole case is about two commercial parties who could not reach an agreement on terms.
And a non-compete clause. Right, they had to agree to a non-compete clause in order to assume the
That was
lease.
Your Honor, that was in the assignment, but that doesn't mean that there was another way to do a deal. If they had reached our terms, I think Mr. Lee would have breached the El Rancho lease and entered into an agreement with Maya. He testified as to that, without the non-compete.
Any further questions?
Thank you,
Thank
Your
you, Ms.
Honors.
Johnson. Mr. McCarty, you have 5 minutes.
Thank you, Mr. Chief Justice. There are a few things about the record that were discussed that I would like to address as quickly as possible. First of all, I would certainly invite the members of the court to read Mr. Lee's testimony about Maya's ability to lease the premises after the El Rancho lease. The jury heard that testimony, and it's absolutely nonsensical. And I think the jury was more than entitled to disregard it.
Do you have a pin site for us?
I wish that I did, Your Honor.
It's okay, you can send it later.
Yeah, but it's definitely there. The El Rancho offer, the non-compete was an extraordinary non-compete that they were requiring. It was that there be no more stores by Maya within 10 miles of an El Rancho location. Okay, 10 miles in a city like Dallas, it might as well be 100 miles. It completely excludes from markets. Next, the statement that I believe is in your bench book from my friend on the other side, she read part of the statement from the record. He gave us an indication that he will go and talk to the owners and come up with an agreement to agree at $750 or $725. He also testified just before this, and you have it in front of you, everybody was happy. Mr. Lee said that, folks, it's not really a big difference. We're talking about 25 cents difference between what you folks want and we want, and we left it at that. So he was still, in December, telling Maya that we're almost there, And they were almost there, but not in the way that Maya thought. Also,
What was the square foot price that El Rancho paid?
$11.25.
Oh, they did pay $11.25.
Yes, they paid $11.25.
Okay. I was confused about whether that was just the offer made to Maya or if that was the rate.
That was the rate, and,
Okay.
and that's an important point, because this idea that in December we're not that far apart, $7.25 or $7.50, when they've got a lease for $11.25. I would say that's not really a truthful statement.
Is there any other evidence in the record about what the market rate would have been?
No, there's contested evidence. They say, the other side said, well, the market was $10.25 or something like that. But that was never conclusive evidence, et cetera, of what the market rate was.
What about, go ahead.
If you're selling a house, you're selling a house and the buyer gets you in the option period, and so the seller's kind of stuck, but the buyer can back out. Does the seller, you have to disclose that to other buyers that they're sort of negotiating with as backups in case the first buyer backs out? I mean, if it is available, you tell the second buyer, the sort of backup buyer, yes, it's available. Well, yeah, we haven't closed, it's
Yes.
available. It doesn't sound false.
I believe that the rule is, and it's a real estate rule, which I have some familiarity with, but I believe that they have the ability to take a backup offer, but that's what is disclosed, that it is a backup offer. It's not a,
Maybe that's in the Realtor Ethics
Yes.
Code or in the
Yes.
law specific to residential real estate somewhere.
Right. That's what I understand, but I'm not incredibly familiar with it, but yes.
It just seems like it's a fairly common situation where a deal it may have been signed, but it's not going to really be in effect until later. You have a situation like that, and one party has the ability to back out, that the party that doesn't have the same ability to back out negotiates backup deals, and
That's fine to
that
have a backup
seems like
deal.
something that happens a lot.
It's fine to have a backup deal, but this was not a backup deal.
Your position is neither side could back out at
Right,
this point.
this idea, first of all, this idea that the non-disclosure agreement and the indemnity agreement never came up at trial, it was never in the record, just absolutely false. It was not only in the record, and in the record before this court, because the lease is in the record before this court, and it's Exhibit 86, it's in the record before you all. But also, the NDA and the indemnity agreement were testified about by Mr. Shalabi in the course of the trial.
And so what's your position on if your client had asked in August or December, do you have a lease with another party, would the NDA provision in the lease have permitted Mr. Lee to disclose the fact of the agreement?
Well, Mr. Lee, and this is critical, Mr. Lee told the jury that NDA prevented him from doing so. That's what the jury heard. And this idea of the magic question, oh, I'm sorry, I'm over time, and I'll sit down if you want, but there's this idea of the magic question. If you just ask this question, we've been lying to you for 6 months, but we wouldn't have lied to you if you had simply asked a different question. And I think that rings hollow.
Any further questions? Thank you, Mr. McCarty. Thank you to all counsel. The case is submitted, and the court will take another brief recess.
All rise.